Good morning, Green Spring. I'm your host today, Avan Price here. And today we are talking about the 65th anniversary of the Brown versus Board of Education court case that went to the Supreme Court. If you residents aren't familiar about it, kind of in a quick layman's terms, is basically the court case that helped break down segregation in the school system, where now blacks and whites would be allowed to go to the same school. And so to give us more insight into the legal process to make that happen, I have Marvin Wagner here, who's going to discuss kind of the legal court case and give us more insight about it. Thanks for coming on today, Marvin. How are you?
My pleasure.
Now, can you kind of give Green Spring a quick overview of your involvement in law and your time as a lawyer?
I spent many parts of my legal career in the criminal area, which necessitated a knowledge of constitutional law. And while I've been here in Green Spring, I've had numerous lectures on constitutional law.
Okay, so you're very familiar on, because my hope is, I only know certain parts about law, so I'm hoping that you can kind of break things down in a much more elaborate way than I could about this court case. And I see you've done your research and you have notes right there.
Right, I'll do the best I can.
All right, before the show, you were saying that to really get a good understanding about the court case of Brown versus Board of Education, we need to go back to slavery time. So I'm going to let you start off and give us a quick history of why we need to go back then to understand the court case that came later on.
Okay, well, the first thing I'd like to do is tell the audience exactly what the Brown case decided, and then we can go from there. The conclusion of the Supreme Court was that separate educational facilities are inherently unequal, okay, and therefore violate the Equal Protection Clause of the 14th Amendment of the United States Constitution. The 14th Amendment is a critical part of the Constitution now, and as I'll discuss later, it's been used in other civil rights issues. The second thing I'd like to mention is the court itself. Earl Warren was the Chief Justice of the court, and he was a new Chief Justice, and this was one of his newer cases. And he felt very strongly that in order to have a real message for the American people, that the decision should be unanimous. And this was somewhat unusual. It's relatively rare for a controversial issue to have a unanimous decision. But Warren worked very hard to convince 2 or 3 of the members of the 9 members of the court to come out with a unanimous decision, and they did.
Yeah.
The court was 9-0 in favor of that. But as you said, in dealing with the issue, we should go all the way back to the early 1700s when slavery began in the United States. Interestingly enough, Virginia was the first jurisdiction that had a slave.
Really?
And it was by accident. The slave ships traditionally had been going to the Caribbean because they needed slaves or black people who could live and work under these harsh, warm conditions of the tropics. And that's what they did. They brought the slaves from Africa and up into the Caribbean. And this one slave ship in the early 1700s landed in Virginia, and the captain of the ship traded one slave for property or things that they needed. And that was the beginning of the slavery in the whole United States. So Virginia has that distinction as well. And as we know that slaves were treated as property, not as persons. And while there were abuses, slave owners were business people, and they didn't abuse them as much as we like to think. They were property. They had to take care of them. They were worth a great deal of money. They cost a lot of money to buy.
Do you know what the average cost was like?
I don't know what it would be today, maybe $5,000.
Wow.
Yeah, I mean, they were expensive. And the real gain in slavery in the United States came about through Eli Whitney, Who's he like? He was the inventor of the cotton gin. And by being able to separate something within the cotton, it made cotton a cash product. And it became valuable for the South because the South had the climate conditions to grow the cotton. So it became a very important product for the South. And they needed the slaves to do whatever work they did. The most critical decision dealing with slavery occurred in the middle 1850s, just before the Civil War. And the most atrocious Supreme Court decision ever made was called the Dred Scott decision.
Okay.
And what had happened was a slave from, I think it was South Carolina, was brought into a state which did not have slavery. And the law in that state said that if a slave is brought there and resides there, he's no longer a slave. That was the state law. He thereafter went back to the South, and he was captured and brought back to one of his former owners.
Okay.
And they said, no, you're still a slave. And the case went all the way up to the Supreme Court as to whether or not he attained the situation of not being a slave when he went to a non-slave state. Okay. And the Supreme Court said that Negroes were not and could not be, and this is critical, a citizen of the United States, could never become a citizen of the United States.
Wow.
And that was obviously a very dramatic case. Take into consideration that at Bunker Hill and Concord, the beginning of the American Revolution, there were black men that were killed in these battles. There were many citizens, black citizens, in states, in the northern states, in perhaps 10, 15 states, where they had citizenship. They were voting. They were a member of the community. And yet the Dred Scott decision said, no, you're not.
So it revoked their citizenship.
Yeah, but obviously in the northern states, they didn't lose their citizenship. But it was a terrible, terrible decision. And that was one of the beginnings of the Civil War, that decision. We won't go into that because that would take a couple hours. After the Civil War, or actually during part of the Civil War, Congress enacted 3 amendments to the Constitution. The 13th, which abolished slavery. The 14th, which established certain rights of many people. And then the 15th Amendment, which granted the blacks the right to vote, called suffrage, black suffrage. Although they sounded great, as a practical matter, in the South, it was as if it never existed. While they weren't actually slaves, many of them were indentured insofar as they rented land to grow crops, and they were indentured to the landowners, and it was a pretty bad condition. They could never vote in any of the southern states. They had really no rights of citizenship. And then we come into the end of the 19th century, 1896. The second major case before the Brown case was Plessy versus Ferguson. It was in 1896. And it's interesting how this was brought about. It's not unusual for a group of people to create a condition, to establish a principle, and then bring it up to the United States Supreme Court. It goes through the various courts and so forth. Now, in Louisiana, they had a law that said a railroad can have separate compartments for white people and black people. And a group of black people decided they were going to challenge this decision. It's a Louisiana state law. And so they had a man whose name was Plessy, who is actually a mulatto, is very more white than black, brown, I guess. And he deliberately went into the white compartment, established the fact that he's a Negro, and he was arrested, and he was fined for a violation of the statute. And of course, then they brought it up to the Supreme Court. And they say Plessy is probably the second worst case in the United States, because it decided that separate but equal conditions was not a violation of the 14th Amendment of the Equal Protection Clause. It said flat out that you can have separate but equal facilities, not just in railroads, because that was minimal. But the important thing was it also talked about the schools, and that was where the main thing was, that school districts can have separate schools for whites and separate schools for blacks. And of course, we also remember the water fountains, where they had separate water fountains for a white person, separate. I mean, it was just horrendous. But the United States Supreme Court said that's okay; they can have that.
The way I saw it was kind of a loophole of the 14th Amendment that said it had to be equal, but this was kind of like the court's loophole way around the 14th Amendment. That yeah, we're equal, but doesn't mean that we have to be together. That we can be separated.
Let me let me read the amendment itself, so
Okay.
we know what we're talking about. This is 14th, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, very important, nor deny to any person within its jurisdiction the equal protection of the laws. Those are the two key parts of it, due process and equal protection. The Plessy case said that equal protection does not apply to this separate but equal, so long as you're giving the black population equal facilities, that's sufficient. And of course, that just wasn't so, because nowhere was there actually equal facilities. There were always far greater white facilities than black facilities. But that was the law up until the Brown case.
Okay.
Let me go back to Earl Warren for a moment. I think we talked earlier.
Yeah, we were talking about him earlier.
That he was appointed by Dwight Eisenhower. It was a deal for California delegates to the Republican nominating convention in 1952. Eisenhower was elected, and he appointed Warren as the Chief Justice. And my understanding is that the agreement was he was just going to be a judge, a justice, not the Supreme Court. Justice, the top law, but he made him so. And I'd just like to spend a minute, if I can, on the Supreme Court itself prior to the Warren Court. Predominantly, it was a group of old men. They were conservatives. They were Protestants. Many of them Southern sympathizers, certainly as related to slavery. And we have the Dred Scott decision, the Plessy decision. And almost from the beginning, that's what the Supreme Court looked like. The two exceptions was Louis Brandeis and Oliver Wendell Holmes. It was the early 1920s. And even under Roosevelt, Franklin Roosevelt appointed some relatively liberal judges. It was still a very conservative court. And Warren changed the whole thing.
Okay.
We could spend an hour just talking about the Warren Court and what they did. But as I mentioned earlier, it was important for Warren that there be a unanimous decision. And let me mention, if I can, what the decision said.
Okay.
On May 17th, 1954, that's when the decision came out, it established racial segregation in public schools are unconstitutional, even if segregated schools and are otherwise equal in quality. So what they're saying is, even if they were equal in quality, they're still unconstitutional. And because that they're not equal, they therefore violate the Equal Protection Clause of the 14th Amendment to the Constitution. And the court ordered the states to desegregate with all deliberate speed. Obviously, it didn't happen for many, many years.
Yeah.
Now, just to go off on a tangent a little bit, excuse me, the importance of this decision went beyond just the question of the school issues, because the other civil rights issues have taken this provision and ran with it, like in abortion cases, in Roe versus Wade. They use the 14th Amendment, equal protection, as the basis of their claims. And same-sex marriage, same thing. They used the 14th Amendment, equal protection rights, as the basis of their decisions, the Supreme Court. So it's not just a black and white issue, the 14th Amendment. Now, in actuality, the Brown case was a combination of a number of different cases that came before the Supreme Court on the same issue of separate but equal. And it's called Brown only because of alphabetical. They were the first, B being one of the first. But there were a number of cases. Interestingly enough, the chief counsel for the plaintiff was Thurgood Marshall. Later became the Supreme Court Justice himself in 1967. Now, one of the interesting sidelights to the Brown case was the national or international view of the United States. We had held ourselves out to be the beacon of democracy, and yet in the South we had these segregated situations, not just schools, but almost everything. And there were many foreign countries that were accusing us of not following through with our own democratic principles by retaining these things. So in a sense, that was one of the issues before the Supreme Court, obviously a sideline issue, but it was important to the members of the court to see the whole international situation.
So the timing of it was kind of like perfect, that it was an international pressure and then the pressure from within.
Another interesting aspect of this, as I mentioned earlier, Eisenhower was not the most liberal of presidents. And the Justice Department, but the Justice Department sided with the plaintiffs. They were on the plaintiff's side in this issue, and that was important. The court looked at the historical education of black children. In 1868, black schools in the South were almost non-existent. They just they weren't there. And there were some laws in the South that actually forbid the education of black people.
Really?
Yeah. And in 1954, they said, "Today, education is perhaps the most important function of our local and state governments." Part of the the reasons that the plaintiff put forth as to show that it's discrimination was a very interesting test that had been given by the introduction of dolls to black children, girls. It was really girls. And this was a test to see what their reaction would be. And these black girls, young girls, 4 or 5 years old, 6 years old, were given 2 dolls, a white doll and a black doll. And they said, which one would you like to keep? And invariably, these black girls chose the white dolls.
Really?
Yes, it was a very important test. And the results of these were brought before the Supreme Court to show the feelings of black people, black children, of their inequality, where they would choose a white doll. A black girl would choose a white doll because the white dolls are better than black dolls.
I remember in my research, they talked about a sociology test that they did, but they didn't mention specifically what the test was. And it said basically, based off a sociology test, that children felt inferior to white children, and that it wasn't best for their development and all that kind of stuff. And that was a major decision in evidence pieces to win the case.
Right. Now here's an interesting quote that they gave. What are the consequences of segregation in public schools? And this is quoted from the decision. To separate black children from others of similar age and qualifications solely because of their race generates a feeling of inferiority, black dolls and white dolls, as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone.
Wow.
Now, the Plessy case was still being cited by the courts all the way up to this point. And that was the law, separate but equal. And there were a lot of important people that felt that Plessy should have retained. And of course, once that changed, everything changed. The whole society changed. Except it took many generations for the South to really bring about equality. Despite the Brown case, the Southern states just struggled. Eisenhower actually had to nationalize the state National Guard to enforce the law. Because they were just not doing it.
Well, in our last 5 minutes, I know that time is flying by. Can you kind of discuss that? Because I find that very interesting that, if the Supreme Court makes a decision for the land, what is the state's response to that, and how, and I think I asked you earlier before the show, how does the Supreme Court, quote unquote, enforce for the state to take on the new law? Like, what is the process to do so?
Well, the Supreme Court doesn't enforce anything. It's the Justice Department which would enforce the laws. And they did in many instances. They literally brought up the National Guard and troops to enforce the law at that point. But the southern states, until fairly recently, and even today, it's not the same, traditionally blocked the blacks from entering the various professions. There were just no rooms for blacks in medical schools or law schools or any of these things. Again, in the southern states, the educational facilities were not really available to many black kids. It was just, lynchings were going on. Blacks fought in World War I. They came back, and the status didn't change one bit in the southern states. They were put right back where they had been before that. Certainly, at least second-class citizens, if not that. Lynchings were very common.
So the people in the states were using kind of a fear factor to scare people.
Yeah, they just ignored. They just ignored the decision. And not just the people, but the states themselves, the state courts themselves ignored it. The enforcement, the sheriffs and the state police ignored the situation.
If you could real quick tell the story about the Virginia and how the private schools that you were telling me before.
Right. There was a Prince Edward County in Virginia. They closed their schools. They closed all of their schools. But then private schools were opened, and the state and the county subsidized white kids to go to these private schools, white schools, no blacks. For 5 years, there was no public schools in Prince Edward County here in Virginia. I mean, this is an example of what was going on. It may be a little extreme, but those were the kinds of things that were going on at the time.
Because when I think about the different results from this case, I remember the story of Ruby Bridges when she went to school. I think she was in Alabama, and how when she was one of the few black kids that were going now to a white school, and basically the school emptied out all the kids, and she was the only person in this huge school, and it was kind of like the town was. Their thought was, we would rather have no one in this school than to share a classroom with a colored person.
Closing the schools completely. The entire school system was closed, and they opened private schools. Today, we still have many issues dealing with whites and blacks, particularly in voting. It's terrible, but it still goes on, and predominantly here in many of the southern states. They put all kinds of barriers to prevent minorities, not just blacks, but all kinds of minorities from voting, because they know that traditionally minorities will vote Democratic, and we're talking about states that are controlled by Republican legislatures, and they're putting all kinds of problems, to minimize the vote.
Now, to wrap up, because time, I said we got to do a part 2 because we should have had a VIM hour special, but we'll do another. Have to come back another time to kind of elaborate on these things. Well, and in your final, quote unquote, goodbye, can you kind of, from a legal standpoint, this. What was the question? Kind of the significance of this case.
Okay.
Like, what is this case in its 65 years and its 65th anniversary? What is the big significance that you want everyone to know about this case?
Well, it's not just the case itself, but I'd like to talk about the 14th Amendment. Because as I mentioned earlier, while the 14th Amendment was designed predominantly for the black issues, for the discrimination of blacks, it has now been extended to go to other civil rights issues. So the 14th Amendment is really a very important aspect of civil rights legislation. As I mentioned earlier, the Roe versus Wade case, gay marriages, these all use the 14th Amendment as the basis of their civil rights issues. And that's very important. And we're going to see more and more of the 14th Amendment being used in other civil rights matters.
So make sure I understand it, because like I said, I don't understand all the legal jargon, but in a layman's terms, kind of Brown versus Board of Education question the 14th Amendment and what it really stood for, and kind of elaborating more on the meaning to make sure it...
And interpreted the 14th Amendment to say predominantly equal but separate facilities are not acceptable. They're not. They are in violation of the Equal Protection Clause of the 14th Amendment.
Well, sadly, our time is up. I appreciate you coming on, Marvin, to talk about this. I really wanted to get more depth and understanding about the legal process behind it than more of the social aspects of this case. And I think you elaborated on it perfectly. We'll just have to bring you back on so you can share more things about it. But thanks again for coming on.